This is Mid-Atlantic Women in Agriculture's Wednesday webinar, Migrant, Seasonal, and H-2A Visa Workers. Our presenter today is Sarah Everhart, University of Maryland Agricultural Law Education Initiative. Questions can be emailed to Sarah. Her email address is provided. And a special thank you to our sponsors, Mid-Atlantic Farm Credit.
I am an attorney with the Agricultural Law Education Initiative, which is a fairly new program. It's an Empower program, and I think that's one of my next slides to explain to you. Empower is the bringing together of two of the University of Maryland schools. It's it's a combination of University of Maryland College Park, University of Maryland Baltimore. So we're harnessing resources from a couple different sources at the University of Maryland, and there's 4 attorneys who are on staff at the Agricultural Law Education Initiative. It's our general goal to help farmers with their legal issues and try to preserve Maryland's farm families. I'm going to go back one slide. Just a general disclaimer, although I am an attorney and I do want to provide everyone with as much useful information as possible, I'm not a private attorney, so I can't give you individual advice. If you hear something today and you think that this might be applicable to your farm, your situation, and you need more specific advice, you should go talk to your individual attorney. But please, that being said, please ask me questions and I'll do my best to try to answer them or point you in the right direction. This is just a slide that explains what the Agricultural Law Education Initiative is. You can see our website there. Our website has a host of really helpful information on it, so I encourage you to take a look at it. We have a blog that can be found on our website that I'm also very proud of. We update it about 3 to 4 times a week, and we try to keep it very up to date with current legal issues, and they're very short blog posts that you can read in 5-10 minutes, and it gives you a good primer on a whole host of issues: food labeling, right to farm, zoning, contractual issues, leasing issues. We try to pretty much cover the gambit of agriculture in Maryland, and we are doing a weekly sort of a news roundup on Fridays, which during the legislative session I think is particularly helpful, so that you could just read a quick blog post on a Friday and you can go into your weekend, feel like you knew what was going on all week. A lot of it's legislative stuff at this point in the year. Okay, so let's dive in. Migrant, seasonal, and H-2A visa workers. I have to say that this is a topic that I don't consider myself to be the world or even the state expert on, but I think, as Shannon said, it's an important topic and one that I've tried to become well versed in. I have worked with Merlin Williams, who I might reference again later if anyone has a question I can't answer. He is at the state at our Department of Labor and License Regulation here in Maryland, and he is an extremely valuable resource on this topic, and he's very willing to help farmers to come out to farms and to provide assistance. So when farmers need to harvest a large amount of crops in a short period of time, migrant, seasonal, and H-2A visa workers can often be a great solution. However, there are very specific federal and state legal duties that are part and parcel to these types of hires, and farmers need to be very careful because there are substantial criminal and civil penalties for failing to adhere to these laws. The federal law governing the employment of migrant and seasonal workers is the Migrant and Seasonal Agricultural Worker Protection Act. I have worked out this acronym as MSPA. I'll warn you, I've seen it in other places done differently. I've seen it done with the AWPA and different variations, but I'm going to go with MSPA for today. The MSPA applies to farmers and agricultural associations who hire migrant and seasonal workers or employ farm labor contractors who supply these workers. It's meant to assure that there's necessary protections for these types of workers, and generally it creates protections for these workers through employment standards related to wages, housing, transportation, disclosures of information, and record keeping. Many of the provisions of the MSPA are also found in Maryland law and may be enforced by the Department of Labor Licensing and Regulation, as I referenced. So when you look at these issues, you actually have to look at both sets of standards, the federal law and our law here in Maryland. All right, what's the difference between a migrant and a seasonal worker? The difference is that a migrant worker is one who is not able to return to their permanent place of residence at the end of the day, because of the distance between the farm and their place of residence. A seasonal worker is a worker other than a migrant worker employed on a seasonal or temporary basis. That's a very broad definition, and I have tried to find some more guidance on who is not included in a seasonal worker, and everything that I have found is very inclusive for that definition. So folks like summer interns, any kind of seasonal work that, you know, is a lot of the work that we have here on farm operations in the state would fall under this law. So I think a lot of people are unaware that the MSPA applies to them because they think I don't have a migrant worker on my farm, therefore this doesn't apply to me. Actually, it does if you have seasonal workers on your farm. The people that are excluded from the definition are immediate family members or any temporary non-immigrant alien authorized to work in the U.S. And then H-2A visa workers are also not included under the protections of the MSPA, which is why we're going to talk about them separately at the end. A farm labor contractor is a person other than an agricultural employer and an agricultural association, or an employee of an agricultural employer or association, who for money or other consideration performs farm labor contracting activities. And those activities are what you would typically think of. These are the folks that go out and recruit workers. They recruit, solicit, hire, bring the folks to your farm, transport the migrant and seasonal worker. To be a legal farm labor contractor, that person must be registered to do business with the U.S. Department of Labor and the Maryland Department of Labor and Licensing and Regulation. It's very important that before you hire a farm labor contractor, the farm owner or operator needs to make sure that that contractor is registered to do business and actually has that proper license. Because if you use a farm labor contractor who's doesn't have that valid license, that's a violation of the MSPA. Oh, did I skip one? Okay, yeah. So let's figure out who doesn't have to comply with this law, because wouldn't that be great? There's two major classes of farmers exempt from the MSPA, and that's family businesses and small farm businesses. To fall under the family business exemption, a person who is engaged in a farm labor contracting activity on behalf of a farm owned or operated exclusively by that person or by an immediate family member. So if you're working for your brother's farm and you're functioning as a farm labor contractor, you actually don't need to follow the provisions of the MSPA. It's only immediate family. So I know a lot of people consider, you know, second cousins or step relations and that sort of thing to be part of their farm family, but you have to be careful because the definition is pretty tight with who is included in that definition of immediate family. And then there's the small farm business exemption for the MSPA. This is the same small farm business exemption that you might have seen in other places. It's the same exemption that's under the Fair Labor Standards Act for minimum wage, and that is that if an agricultural employer did not use more than 500 man-days of labor in any calendar quarter of the previous year, then they're considered a small farm and they don't need to comply with the MSPA. I did a little example for you here because that definition is hard for me personally to get my brain around, especially because a man-day is any day in which one non-family worker works at least 1 hour. So my example here is if you have 7 workers working for 5 days a week for 13 weeks, which is a quarter, then you only have 455 man-days, which means you would be just under the 500 man-days and you would qualify as a small farm. If you have any more than that, then you're not going to be a small farm and you're going to need to comply. So let's move forward with thinking that this law does apply to us. Non-exempt farm labor contractors, agricultural employers, and agricultural associations who recruit migrant and seasonal workers are required, now we're going to get into what exactly you need to do because of this law. The first thing you need to do is you have to provide the migrant workers with a contract in writing in English or in their primary language, Spanish or whatever it may be, at the time of recruitment or offer of employment, meaning before the worker has accepted the position. The seasonal worker only has to be given a verbal description of the job, and then if they ask for something in writing, they have to be provided something in writing. But a migrant worker has to be provided something in writing before they accept the job. I would say, as a rule of thumb, anytime you need to provide, the law requires you to provide somebody with something in writing, you should definitely retain a copy of whatever you provided them so that if you were ever questioned later, you could have evidence that you actually provided that in writing. The contract has to include the place of employment, the wage rates that you're going to be paying the worker, the crops and kinds of activities that the worker will be employed doing, the period of employment, transportation if that's available, housing if that's going to be available, and all other benefits, as well as any cost that the worker will be charged for the housing or for transportation. The law also says if you have any kind of a strike or concentrated or work slowdown going on at your farm, you need to inform them about that, and then you also need to give them their workers' compensation insurance rights in that contract too. The whole point, I'll go back to this one for a second, sorry. The whole point of this really, and I think I mentioned this in a slide or two, is that this is to avoid a bait and switch situation. I mean, we're talking about a migrant worker who's going to be very far from their principal place of residence, who's coming to your farm to be your employee, and this requirement would eliminate you from making an offer and then rescinding the offer or changing the deal. This allows the person to have a full scope and idea of what kind of work they're going to be doing, what they're going to be paid, their full benefits package before they accept the job. So like I said, if workers' compensation insurance is provided, workers must be told of the insurance carrier, the name of the policyholder of the insurance, all that information, the telephone number where they would need to report a claim. And then all of that information, the information that I just went through, those rights that the workers have must be posted in a conspicuous place somewhere on the work site. And the Department of Labor has pre-printed posters that they can provide your farm so that you don't miss anything, or so if in case you wanted the poster to be in Spanish instead of English, you can get those directly from the government so you don't screw any of that up. And as I said, this is all to prevent the bait and switch, whereby a person would arrive to your farm and then the terms of the employment are actually different than what was offered. What's interesting about the MSPA is that the farm labor contractors, agricultural employers, and agricultural associations have an obligation to consistently pay wages, and that you have to give written pay stubs with all of the earnings and the deductions directly on the pay stub, so it's very easy for the employees to read. And you also have to retain copies of all of your pay statements for a period of 3 years. So you basically have a 3-year window whereby the government could come back and say, we want to see all your pay records, we want to make sure that you paid those folks the proper amount. But it doesn't actually define the rate that you have to pay your workers. The rate that you would have to pay your workers would, of course, be dictated by the Fair Labor Standards Act and or state law. So in Maryland, we have our own separate minimum wage, which is currently higher than the federal standard. And 2 counties in Maryland actually have a higher minimum wage than the state standard. So you have to look at the federal standard, the state standard, and then if you're in those 2 counties, which I think are Montgomery and Prince George's, you actually have to pay a little bit more. So as long as you met the minimum, as long as you had to pay those folks minimum wage, which in most cases you do. That's what you have to pay them, but that isn't actually a part of the law. Okay, so obviously if you have migrant workers on your farm, in a lot of cases you're providing housing for those folks. It's your responsibility under this law to ensure that the housing is in good condition and that it meets all federal and state safety and health regulations. I would add to this that if you're planning on incorporating migrant workers into your operation, you need to also be sure that you can have group housing on your farm. I would make sure that you've cleared this with your county zoning office. Group housing of this type isn't always authorized in every zoning designation, so I would make sure that it meets local, federal, and state law. And I would start with the local to make sure that you can have that type of housing on your farm. Similarly, all non-agricultural vehicles used by farm labor contractors or agricultural employers must meet federal and state safety standards, be fully insured, and be driven by licensed drivers. One interesting sort of legal concept here to understand is the concept of joint employment. This concept sneaks up on a lot of farmers and has been litigated across the country many times in relation to this law and actually in relation to the Fair Labor Standards Act. Joint employment occurs when a worker is jointly employed by a farm labor contractor and an agricultural employer because of the level of control the agricultural employer has over the contractor. This is sort of, it's analogous to whether somebody's an employee or an independent contractor, if anyone's familiar with those standards. There's a number of legal considerations that a court will look to determine if a joint employment situation exists, but generally, if an agricultural employer has the power to direct, control, or supervise the workers, or to determine their pay rates or method of payment, the agricultural employer and the farm labor contractor are the joint employers of the workers. No one element really controls. It's sort of it's looked at in the totality, and the joint employment situation, it occurs, it can sneak up on folks because in some farming operations, the agricultural employer will hire a farm labor contractor and say, you know, you're responsible for going out and finding me workers. This is how much, you know, how much harvesting I'm going to have to do. You need to go out and find me workers. You need to round them up, bring them to the farm. You're in charge of paying them, overseeing them, supervising them, and making sure everything gets done. In that situation, the agricultural employer is really taking a step back and giving the farm labor contractor the right to control the whole situation. By contrast, if the agricultural employer hires the farm labor contractor to recruit workers, but then once the workers get to the farm, the agricultural employer is overseeing them, has the power to direct the workers, is actually acting as a supervisor, him or herself, determining pay rates, controlling all the payment, then actually those workers are employed by two different people. They're employed by the farm labor contractor and the agricultural employer. The issue with this is that if the farm labor contractor, if there is a joint employment situation, then the agricultural employer is equally responsible, along with the farm labor contractor, for any noncompliance with the MSPA and the FLSA obligations. So, for example, you know, I told you you have quite a few obligations at the time of offer of employment. Well, if you're in a joint employment situation as the agricultural employer and you weren't there at the offer of employment because the labor contractor handled that part of the transaction and he or she didn't actually do everything they were supposed to do under the law, and you're jointly employing that worker, now that worker is going to sue both of you for those violations, and you're both going to be liable for all the violations of the MSPA and the Fair Labor Standards Act, which is the law that the worker would sue you under if they weren't paid correctly. This liability can be very significant, and it can be an unwelcome surprise for people that are turning a blind eye towards the actions of the farm labor contractor. This is another reason why you want to be very confident in your farm labor contractor. Make sure they have the proper license. and make sure that they understand all of their obligations under this law, because you could be found liable for all of their actions or misactions as well. Okay, enforcement. If you have the unfortunate situation of facing the enforcement provisions of this law, the penalties are severe. Anyone found violating the MSPA may be fined or sentenced to prison. Subsequent violations carry a fine of not more than $10,000. The fines are very high. One unique feature of the MSPA is that it permits anyone aggrieved by a violation to bring a private lawsuit in federal court regardless of the amount in controversy, the citizenship of the parties, or whether all administrative remedies the Act provides have been exhausted. This might not be very dramatic for non-lawyer folks, but this is a huge, huge benefit that these workers are getting under this law, to be able to bring a lawsuit in federal court regardless of the amount in controversy, regardless if you're a U.S. citizen, and regardless whether you've taken all the steps you needed to take before going to court. This is a very powerful enforcement tool, and this is done on purpose to empower workers to be able to sue agricultural employers and to bring violations of this law to light. But this would, if somebody worked for you for a couple months and you, let's say, you were in the wrong and you only owed this person a couple $1,000, $10,000, that sort of thing, they could still bring you to federal court and sue you for that, and you would actually end up having to pay probably a heck of a lot more than that in legal fees defending the suit. Finally, the law contains a whistleblower provision prohibiting any form of retaliation against a worker who's filed a complaint or instituted proceedings under the law. And the last thing I really have to say about it is that there's also significant penalties under the Fair Labor Standards Act, which I've mentioned, for improper payment of wages. So if a worker is improperly treated, including the improper payment of wages, the farmer is going to be facing a suit for under the MSPA and under the Fair Labor Standards Act. Does anybody have any questions about migrant or seasonal before I go on to H-2A visa? You guys can think and then just type in the chat if you think of one. The H-2A Visa program, oh, okay, good, I got some questions. I'll wait. I'll take a breath and wait. Okay, great. Okay, the H-2A Visa program is the non-immigrant seasonal foreign visa worker program for agricultural employers. In Maryland, the H-2A visa program is very common. When I talk to folks at the state about the most common types of operations that use these workers, they told me nurseries and fruit and vegetable operations, and actually Christmas tree farms were amongst the operations that use the most H-2A visa workers. Generally, the program requires that a farmer prove to the federal government that foreign workers are needed because American workers are unavailable for the work, and that to do that, the farmer must provide the foreign workers with transportation, safe housing, fair wages for the duration of their seasonal employment. In order for a foreign worker to apply for an H-2A visa, a worker must have a job offer from a U.S. agricultural employer, and we'll go through the process here in a slide or two. Agricultural employers typically work with recruiters who identify foreign workers with the necessary skills for the job. I can't say this enough, but I'll say it one more time. The state is very helpful with this process. So if H-2A visa workers are something that you are considering for your operation, I would encourage you very much to contact the state, and they're really willing to offer people a lot of assistance to get these kind of workers here. So here's the process. If you want to hire an H-2A visa worker, you first have to submit a job order to DLLR at the state at least 60 days before the day the worker is first needed. So that's sort of the first thing in the process, is this job order. At least 45 days before an H-2A visa worker is needed, the employer must also apply with the Department of Labor for a temporary labor certification. To be approved for the temporary labor certification, you must demonstrate that the job is of a temporary nature and there's not enough U.S. workers who are able, willing, qualified to perform the work at the place and time needed, and that the wages and working conditions of workers in the U.S. will not be adversely affected by the importation of guest workers. Basically, you have to advertise in a U.S. newspaper, and the state can help you with this process. You have to advertise these positions. According to the folks I was talking to at DLLR, they assist you with placing the ad in a newspaper down in Florida, and the ad has to run, and depending, if you don't hear any responses to your ad request for U.S. workers, then you move forward, and that's how you prove to the government that you can't find any U.S. workers who are able, willing, and qualified to perform the work. So if you're approved, then you file a petition for a non-immigrant worker with the U.S. Citizens and Immigration Service, and once the petition is approved, a prospective foreign worker can then apply for their H-2A non-immigrant visa at the U.S. Embassy or consulate in their home country. Agricultural employers are advised that the application and approvals for H-2A visa workers can take up to 80 days to complete. They wanted me to, when I told the folks at the state of Maryland that I was going to be doing these sorts of presentations, they wanted me to emphasize that to you all, that this process takes 80 days. I don't think so, Tricia. Tricia's asking me if the ad would have to be placed locally as well. I don't think so, but that is something that I would confirm with DLLR if I were you. I remember specifically asking that question, and if I'm recalling correctly, they have a system whereby they place the ads in states where there's a lot of agricultural workers. And so they told me that those ads only have to run in Florida for whatever reason. Our ads for farms here in Maryland. So the last thing I have on this slide here is just how much assistance. It's called the Maryland Job Service Rural Service Coordinator. It's a mouthful, and those are the folks at DLLR who can help you with this. Oh, okay, thanks, Laura. Virginia, Florida, and Texas. Wow, okay. Thank you for that information. That's more than I thought. Laura's telling us that she had to apply locally and in Virginia, Florida, and Texas on our chat board, so that's more advertising than I thought. Okay, an agricultural employer must pay a wage to an H-2A visa worker that is at least the higher of the local prevailing wage as determined by DLLR and the Department of Labor, the state or federal minimum wage, or the adverse effect wage rate, which is the average wage of non-supervisory field and livestock workers as determined by a USDA survey. That's a mouthful. Basically, that means that in contrast to the MSPA, H-2A visa workers have very specific wages they need to be paid, and they need to be paid at least, they need to be paid the higher of the prevailing wage or this adverse effect wage rate, which is set by USDA. Employers must also provide H-2A workers with pay stubs, just like in the previous law, throughout the course of the employment, which itemize all the earnings and deductions, and which they must retain for a period of 3 years. Employers soliciting H-2A visa workers must also provide all the workers' compensation, insurance, but you don't have to provide health insurance coverage. DLLR does perform audits of agricultural employers to ensure that the workers are being properly paid, so just as I said before, anytime you have an obligation like this under a law to protect yourself, make sure you do a very thorough job with keeping your documentation for the proper period of time and keeping it organized in case you did face an audit. In addition to wages, employers must provide all H-2A visa workers who can't return to their principal place of residence within the same day, which is the majority of them where we're located here in Maryland, housing at no cost and either 3 meals a day or adequate kitchen facilities so the workers can cook their own meals. The housing provided must meet federal, state health and safety standards. And again, I would implore you to do the same thing as I said previously. Make sure you check with your local zoning offices to make sure you can provide that type of group housing on your farm. And pursuant to federal regulation, employers must offer U.S. workers the same benefits, wages, and working conditions that are offered to similarly situated non-H-2A workers. So if you have some U.S. workers on your farm doing the same jobs as H-2A visa workers, pursuant to federal law, actually the U.S. workers are supposed to be offered the same wages and benefits that are being offered to the H-2A visa workers. Okay, the transportation costs to get an H-2A visa worker from their home country to the farm, to your farm in the U.S. are required to be paid by the agricultural employer if the workers completed at least 50% of the work contract period. Employers are also responsible for providing transportation to and from the farm to H-2A workers at no cost. And upon the expiration of the contract, the agricultural employer shall pay for the workers' transportation costs home. So these are some added costs that people need to be aware of, and make sure you factor that into having these types of workers in your operation. Once hired, an H-2A visa worker is guaranteed employment for at least 3/4 of the work days described in their employment contract. A work day is actually, it's a little bit easier to think about as hours in a work day. My example is if you promised a 40-hour week, you as the agricultural employer have met your burden by providing at least 30 hours a week of work. So you have to provide at least 3/4 of what you promised. If you fail to provide at least 3/4 of the work days originally promised, then the worker is still, the worker has the right to be paid for 3/4 of those days of work. This is an important thing to realize and sort of digest because, you know, as we all know, some things happen on farms, there's inherent risk, and sometimes you might end up with less work than you had originally intended. But this type of worker has this protection because they're brought to the United States specifically to work for you and your operation. They're unable to go and supplement their income, go find another job like a typical employee would. You know, in the face of a crop failure, you would tell a U.S. employee, sorry, you're going to have to go find some more work at another farm. You know, I've had a disaster here and I don't have the work for you. If you have an H-2A worker there, you have to pay them for 3/4 of what you promised the work. So it's something to think about and keep in mind. H-2A workers definitely get benefits that aren't provided to migrant and seasonal workers, such as the transportation costs we talked about, free housing, guaranteed wage rates. However, the enforcement provisions of the H-2A, Lisa's asking me a question here. Is this spread throughout the season or weekly? You're talking about the 3/4. 3/4 of the work days. I think that would be total, Lisa. I would break that down. Total. I think that if you had one slow week where somebody worked less than what they were entitled, I think you would look at their contract period for the season, and that's how you would work out whether you met that 3/4 of the workdays obligation, not just per week. I think you can have one slow week and then catch it up the next week. So as I was saying, although H-2A visa workers have some additional benefits compared to migrant or seasonal workers, the enforcement provisions of the program are pretty weak by comparison. There is a procedure whereby workers can file complaints with the Department of Labor, but there's no specific enforcement provisions similar to those in the MSPA, such as that power to bring the lawsuits and the private lawsuits in federal court. They don't have that type of authority. So, or they don't have that type of, they just don't have the strength and the enforcement that the MSPA gives those types of workers. On receipt of a complaint, the Department of Labor really has the discretion to take the enforcement action. But I say that, and that's true under the law, but like I said, I also spent some time talking to the folks at the state about this, and they told me that they do keep an eye on farms in Maryland, and they do perform their own audits to make sure that workers are being treated properly.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel, or to find a schedule of upcoming live webinars, visit our website.